71 of 2023. Daudi Mwangi, Daniel Mugwe, Simon Mutembei, John Julius Tasso, Samuel Kanyede, Julius Ndengwa, Njenga, John Maina, Kabisa, Utajua, and Joy Mutu.
Yes, yes. Good morning.
Number 9 is Maina Njenga. I don't know whether to give you presentation first.
Yes, yes.
Okay, I appear for Maina Njenga alongside Ndengwa Simon Buru, Mr. Cheche.
Simon Buru.
Simon Buru is beside me here. Mr. Cheche at the back there, and Mr. Munji. Mr. Munji.
Munji.
Yeah. I hope I'm pronouncing properly. Right behind you.
This is for the 9th accused.
Sorry?
The 9th accused.
9 accused, yes, who has not taken plea.
Thank you.
Yeah.
Prosecutor?
Yes,
Your name, please. Yes?
Miss Maina.
Yes, Maina. Mr. Omwenga. Yes.
Is the resident prosecutor?
Yes.
Okay. Your Honor, we do have a fresh charges that have been registered in respect to the accused person. Your Honor, maybe behind that, maybe you can confirm whether we have a charge sheet.
Yes, I
Because the
delivered.
one that is in respect to 3/11/71.
Yes.
And everyone has been registered. We intend to have the new one.
What happens to this one? I actually am aware there are 2 files.
Okay.
Yes, and I deliberately asked that this one be ordered.
We agree.
So what happens to this one?
Your Honor, we wish to have this 11/71/23 to be retained to have a mention
Yes.
on 20th of June
Yes.
as stated, so that we can be able to proceed with the case. Then we will make the necessary applications.
I think, Your Honor,
Yes.
technically there is something wrong with that because there are already existing charges, and unless they are withdrawn, even though he has not taken plea, he has been charged and it's before you. So unless those charges are first withdrawn, it would not be right for the accused to plead in a different file, because then you'll be facing a multiplicity of charges. So it's up to the prosecution to decide what to do, whether to first withdraw the existing charges, and I think this is something they know. You can't have several files in respect of the same person. I don't want to say much more at this stage, but we want to object to taking plea when there is a multiplicity of charges into different files. colleague, Mr. Njiro, would like to add something to that.
Please, you know, I didn't say anything.
Just a minute.
You know, I join issues with what has been submitted by Maina and Hansel Manda. And add this to say, you know, that we certainly be able to see the mischief behind this process that is being initiated by the DPP with the aid of the DCI. You know, while I am not at the point of dealing with the substantive of the charge, the process of the charge itself is questionable. You know, this charge that is before you in E1171 was read out to the accused persons on the 19th of May. The same proceeded in the absence of the 9th accused person. Previously, Your Honor, the 9th accused person had procured an anticipatory bail in Nairobi in miscellaneous application number E165/2023.
You say by what?
Miscellaneous application number 1 is 165 of 2023. And I'm pointing it out, Your Honor, for you to see the mischief. In that application, Your Honor, which is coming up for mention on the 6th of June before the Honorable Judge, there was a condition of that bill to the effect that upon a decision to charge being made by the relevant organ, the bill was to lapse. With that knowledge, Your Honor, and with the intention to perpetrate the mischief that we are addressing, the DPP, even having been served and or having knowledge of that order, decided to charge the accused person on the 19th. And the consequence therefore was that the order lapsed. You know, upon lapse of those orders, the DCI on the 24th of May circulated a communique. 24th of May. The DCI circulated a communique on their social media page that the accused person, the 9th accused person, is at large. And they called the members of the public that any person who knows of his whereabouts does report. Remember, at all this time, Your Honor, the accused is not aware that a charge has been preferred against him. Yet a communique of a person who has gone large has been sent out. So, having learned of that, Your Honor, we voluntarily appeared before court number 3 on the same day, 24th, to have the accused person take plea under 11 under file number E1171. We pleaded with the court. The records bears as witness, and the court declined. The court abdicated on that duty. Subsequent to that, Your Honor, that judicial application, we were ordered to appear before the DCI on the 25th. We did appear. I do not want to recount on the drama that ensued therein. we'll do that later. But suffice to note that on that date, we informed the DCI that there is a charge that is pending before this court, and that the charge has a date of the 20th of May when the accused person was to appear and take plea. Look at the mystery. To date, when the live file 1171 has been called out, all other co-accused persons are not before you. And what does the DPP do? He decides to bring a new charge. A replication of the charges that are before you. What that technically means, Your Honor, that one, that the accused person together with his co-accused are facing fresh charges. Number two, that these fresh charges are arising from the same transaction. Number three, that there will be another separate file. There could be an argument that a consolidation will be done in the latter date, but that should not be a prima facie presumption, because consolidation is not obvious. And that is the malice we are pointing out. And that is the abuse of the court process we are pointing out. And objecting to the taking of the plea until the DPP does put his house in order. And the objection, Your Honor, is that it is going to fly over the face of Article 50. Infringe that right. Infringe the right under Article 48, access to justice. Infringe over client's rights under Article 27, equal treatment and equal protection before the law under the principle of non-discrimination. Whereas, Your Honor, you must know that Article 25 caps and protects the rights under Article 50. It's a non-derogable right, the right to a fair trial. The question therefore is,
Article 25, that's what?
it protects the rights under Article 50 by creating a caveat that that's a non-derogable right. So the question of your determination is, if he was to take plea as proposed, would that amount to the infringement of that right?
The question of which?
If the accused person was to take plea as proposed in a separate file, bearing the same transactions, the same offenses, the same particulars, would that amount to the infringement of his right? And that's for 50. Number two, would that amount to a double jeopardy? Most of that.
Yes.
Your Honor,